Okay, closing arguments at this point on the defendant's motion for new trial, which is at DIN 3742. And since it was the defendant's motion, I'll let the defense make any arguments you wish to make at this point, if any.
So based on the testimony, it comes down to the credibility fault you make on what he said here. And I've asked for questions. We'd like to have gone to the things on the other area, but I believe you've made a clear ruling on that, so there's no reason for me to argue further on that. I do believe that those things weren't bound by a 15-day and that we had good cause for why we did it somewhat later. But
well, the judge already said you're wrong, so. Okay. That was the ultimate Hail Mary of all Hail Marys passes. That was, I mean, that is their final argument. Well, we just, I'm going to make this lame argument, and then I'm going to sit down. That's the last thing they have to offer. He doesn't even believe this himself. This credit. Listen to his own tone of voice. His tone of voice is utterly defeated on this credibility issue. That is their last ditch, and that's all they've said in the past two motions. And the motions in the supplement was, but even if he gets on the stand, he's just going to lie without offering a single piece of evidence that what he was saying was a lie, that he did anything wrong. It's all just feelings, hunches, assertions, allegations, not a single shred of evidence that anything juror number one did was wrong. And that's all. That's once you pull that rug out from underneath him, that's all he can say is, well, credibility, Your Honor. Listen to his tone of voice. He's not even convinced. 4-2. And since it was the defendant's motion, I'll let the defense make any arguments you wish to make at this point. He's just defeated. His voice is defeated.
It comes down to the credibility fault you make on what he said here. And I've asked for questions. We'd like to have gone to the things on the other area, but I believe you've made a clear ruling on that, so there's no reason for me to argue further on that. I do believe that those things weren't bound by a 15-day and that we had good cause for why we did it somewhat later, but you've ruled. So
thank you. Plaintiffs.
The court essentially wrote our argument on January 2nd, 2024. Your Honor, it's time to put this to bed. There was no ambiguity in the witness's testimony. He was straightforward and looked at the court. I would note for the record, at least I recall that the witness used reader glasses at times during the proceedings if he had something important to see here. And there's no reason to doubt this gentleman's honesty and integrity and the answers to his questions. So we ask that their motion be denied.
Court has before the defendant's motion for new trial based on juror misconduct, which is at docket identification number or DIN 3742. There were various supplements. Certainly the record is going to reflect the various different supplements, responses, interim orders, reconsideration, orders on reconsideration. At the end of the day, the defense has failed to demonstrate any juror misconduct. The court will therefore deny the motion for new trial based on alleged juror misconduct. That concludes the juror interview. I certainly still have a number of motions pending that we argued before the court on December 15th. Those remain pending, and I still need to address those. So my hope is that on or before Monday, January 22nd, that I will have answers to all of those outstanding motions one way or the other. My hope is to do it before then, but I'm giving myself a little more than 2 weeks to go through those motions now that the juror issue has been taken off the table, and I can focus on those because I've been spending all my time on the juror misconduct allegations. So that is my plan on a going forward basis. Are there any questions, concerns, things we need to address in the interim?
So he just flat out, and I was actually thinking, just for appearance's sake, at least he might say, thank you for the arguments. Thank you for this. I'll take it under advisement and give you my decision in a few days. I thought he might do that, but he just straight out said, yeah, the defense stuff ain't going to happen. I mean, to be fair, essentially what he told the defense was
everything that guy just said is bullshit. Thank you.
He just flat out denied it. Just denied. We're not getting a new trial based on juror misconduct. So put that to rest. Don't ever talk about it again. We'll address the other issues, the other subjects of the motions at a later point in time. Anybody got a problem with that? Is what he's asking now.
Yeah, the only thing I'd comment is that I was going to check with the court reporter to see whether there was going to be a trial transcript anytime soon. And I did not do that this morning, but I will check on that tomorrow and provide the court with information.
I appreciate it.
Are we boring you, Shapiro? Look at Shapiro. He's just messing around on his phone. I don't know if it's just because that phone is behind the lectern and behind the screen and the judge can't see it. But I just know that in any courtroom I've been in Utah, and especially in Korea, if the judge saw him dicking around on his phone like that, the judge would utterly crush him. Shapiro has been noticeably quiet. It's like, little man, you put us in this position. Let the old boys talk here. Let the adults talk and try to salvage this. He sat there very quietly looking at his stupid computer screen and playing with his phone the entire time. Oof. Again, that went almost exactly as I predicted it would go. The judge is done with this. He wants to hear nothing further about this Juror 1 issue ever again.